over to Michelle Tucker. Tucker, take it away.
All right. Good morning. Thank you, Bill. And thanks everyone for joining us. I'm watching our attendee list continue to grow, so I assume we'll have some additional folks dropping in. As Bill indicated, my name is Michelle Tucker. I'm the Vice President of Enterprise Comp Operations at CorVel. We're so excited that you could join us today to talk about yet another change in California, Senate Bill 1159, which has to do obviously with COVID, new COVID reporting requirements, and compensability, eligibility for workers' comp. I'm pleased to have joining me today, and I'm going to be handing off to, at this point, Brenna Hampton. Brenna is the managing partner of Hanna & Brophy's San Diego office. She's also a California State Bar Certified Workers' Comp legal specialist, and has been gracious enough to join us today to share with us what we know now currently about the legislation, and maybe give some insight into what the future looks like. And certainly, since we have a lot of content today, I'm going to move through formalities quickly, and with that, I'm going to hand it over to Brenna. Brenna?
Thank you so much. I'm happy to be here, and would invite anybody to follow up with questions. I want to acknowledge at the outset that what we're talking about today can feel very you'll be very empowered and understand exactly who has the rights and responsibilities that are created by this bill. So just a little bit about me, as well as Michelle announced, I'm a certified specialist through the State Bar of California. I practice exclusively California workers' compensation defense. That's what my firm does. We only represent employers, and we are litigators. So I paid a lot of close attention to this bill when it started becoming announced, and it was clear from the outset that 1159 was going to be the favorite bill from a legislative process perspective. So I do want to give a very lawyerly disclaimer here that nothing I'm going to say today is intended as anything other than general advice, okay? So if you do have any specific questions regarding your particular employment site, defining your employment site, as we'll see that's a big issue, specific cases that are coming across your desk, I'm more than happy to talk to you individually to give personal advice. But every case is going to be different. We deal with workers' compensation, so we're dealing with individuals, their medical history, their unique set of facts, and then of course you as employers and TPAs are going to have very situations as well that all have to get factored into this. So please don't leave your webinar today and go back and quote me to anybody and say, Brenna said you always have to do this. Other than your basic reporting requirements, you're really going to have to do something different in every case and think through your strategy in a meaningful way. So hopefully we're going to give you some tools today that will allow you to launch that analysis. So here's the roadmap of what we're going to discuss today. COVID-19, just a little bit of background on this, some current statistics for you data geeks out there like me. I would like to see the numbers, just gives it some context. The Senate Bill 1159 itself, what it is and how we got here. And then we're really going to spend the bulk of the time on my portion of the presentation today talking about what comes next, or really what comes now, because this bill became effective when the governor signed it on September 17th. So if you don't already have processes in place for your reporting requirements and for the other responsibilities that inure under this bill, you do not have time to waste, okay? I'm not a fire and brimstone kind of person, generally speaking, but really, guys, you don't have time to waste on this. You got to get moving. All right, so a little bit of data to get us started on this lovely morning. First of all, the data to the right was captured a few weeks ago. At that point, we had 800, sorry, on your left, depending on how your screen is oriented, we had on September 27th, 800 positive cases. As of just the other day, we could see an increase already to 823 positive cases and over 16,000 deaths attributable to COVID. Now, I know there's some debate about whether all those deaths really are attributable to COVID, but in order for that number to happen, there has to be some plausible link to COVID-related illness, okay? And just like in workers' compensation, if you have a death case, it's a very minimal standard to attribute that death to COVID. So the numbers are what they are, but the most important thing is that the numbers are still going up. we do not yet have a plateau or total control over the spread of this virus. Another statistic that's not on this slide is that the bulk of the positive cases in California are in the 18 to 65 year age range. And what that means is that it's the college and working age population that are mostly affected by this virus. There's a lot of data about children and infants carrying the virus, but those who are deeply impacted are those who are active and who are out there in the workforce. So as employers, it should give us all some pause. I'm an employer too, so I get this perspective. We need to take care of preventing the spread of COVID at our work site. So we'll talk a little bit later today about how to do that. And OSHA has issued some very specific guidelines, and now under SB 1159 and another bill that's going to be effective in 2021, AB 685, those guidelines have been given some teeth, okay? So you have all that to look forward to at the end of my portion of the session. But first, let's talk about how we got here. Okay, so we had the executive order, and anybody who was alive and doing workers' compensation several months ago was very familiar with Governor Newsom's order. It basically enacted a rebuttable presumption for dates of injury between March 19th and July 5th, 2020. Okay, there was a requirement under the executive order, similar to what we have under SB 1159, that the employee have tested positive within 14 days of their last day actually worked at a job site. Does not apply to employees working at their home or residence. Okay? Now, the last effective date of the executive order could be seen as going through July 19th of 2020, because an individual who last worked on July 5th would still have had 14 days in which to test positive following their last day of actual work. So it's a kind of running theme as we talk about this bill. We need to know when the employee worked, when they were potentially last exposed, and then we need to know when they tested. Okay, so those are key points that follow through all of the presumptions we're going to talk about today. Then after the executive order lapsed, Governor Newsom didn't renew it. We know, having been slightly involved in the proceedings, there were a lot of lobbying events going on both sides, and we had a lot of sort of stop-starts to get to the current bill. At several junctures, it looked like we had a working bill in place, and then negotiations would continue. So that happened over the course of the next month and a half or so, which means we have a gap period. Okay, the gap period runs from July 6th to September 17th, when Governor Newsom finally signed the bill. During that period of time, there was no law in effect. It's important to understand that as soon as Governor Newsom signed this bill on September 17th, its provisions are retroactive. So all of that gap period, dates of injury that arose after July 6th and before September 17th, are covered by some provision in this new bill. Okay, so we cannot say going back that there was no presumption in effect during the gap period. There absolutely is. Even though if you had a claim filed at that time, it may not have been covered until the governor signed SB 1159. But this is really just a long way of saying that SB 1159 is retroactive. It applies to all pending and open cases. If you were lucky enough to have a case filed that you've settled by compromise and release, or somehow got to trial expeditiously, those are done. They cannot be reopened based on this new law, but any case that is open and pending is covered by SB 1159. So SB 1159 passed. That's why we're here talking about it. It was an all-night session, and the session went on past midnight. Now, there were two other bills, AB 196 and AB 664, for you legislative junkies out there. They were very conservative in terms of granting, I should say very liberal in terms of granting employee rights. And some provisions would have gone all the way back to cover all employees, regardless of work classification, to January. So if you're grunting and groaning about SB 1159, just be glad, because it could have been so much worse. But 196 and 664 were not marked as urgency statutes. So given the midnight hour, they essentially died on the floor. So all we're doing now is talking about SB 1159 when it comes to a workers' compensation presumption in the state of California. All right, now for all you visual learners out there, this is an overview of SB 1159. So the first section, section 1, orders a claims impact study to be delivered to the legislature by the end of next year. Okay, hopefully they do some good things with it and we don't see further amendments that add additional employer responsibilities. I think in the next year, if employers can responsibly manage these claims, hopefully we'll see a decrease in COVID claims, and we may even see a request to sunset the COVID statute earlier. Right now, it's set to sunset in 2023. Okay, so if nothing else happens, all the rules we're going to talk about today last until 2023. The three sections in the middle going across your screen are the presumptions. Section 2, which is Labor Code 3212.86, creates another rule that essentially overlaps the terms of the executive order with a couple simple tweaks that we'll talk about. Section 3 created Labor Code 3212.87, and it's a narrowly defined class of employees that qualify under this section. It sort of carried on the tradition of favoring the rights of first responders and safety officers, and then also added a similar for certain healthcare workers. We'll talk specifically about who qualifies and where they have to be working at the time of injury to qualify. Section 4 created Labor Code 3212.88. Now, as an employer working with employees in the state of California, this is your new favorite / least favorite section of the presumptions, because this is where we find all of the responsibilities for employer reporting, civil penalties from the labor commissioner for failure to properly report, and stuff. So we'll get to that, and that's where we'll spend the bulk of my time today. Section 5 down below basically just says this is an urgency statute, and as soon as the governor signed it on 9/17, it became legally effective. All right, so if you like to read statutes, here's the actual language of Section 1. Just creates that claims impact study. Section 2 is the codification of the executive order. Now, all of the bullet points on the top of this slide, it applies to dates of injuries through 7/5. There's a 30-day investigation period that starts from return of the claim form by the employee. It requires a positive COVID test. It creates a rebuttable presumption. So if all the provisions of this section apply, the employer, the defendant, still have an opportunity to challenge that the injury was industrial. That's all that rebuttable means. We don't lose automatically, okay? And also the temporary disability rules for administering indemnity benefits under Section 2 are the same as under the executive order. In essence, it required that an employee recertify for temporary disability every 15 days for the first 45 days following the diagnosis of COVID. Now remember, under the executive order, they could qualify by a diagnosis that was further followed up by testing. And now we see that testing is going to be required as a PCR test. Okay, that's the polymerase chain reaction test. Essentially, we need a test that validates that there's a live virus in the body. The antibody testing, which looks backward to see if the body developed antibodies to a virus at some point, is specifically disallowed by statute. Now, there are a couple changes in Section 2 versus the executive order. And again, because Section 2 is now the law, we're not following the executive order, we're following Section 2 for periods of injury from 3/19 to 7/5. We have to understand what Section 2 says. So the two major differences, the first one I think is beneficial for everybody. It clearly defines date of injury as the last day that the employee actually worked, not just was employed, prior to their positive COVID test. Now, some of you might say, well, what's the date of the positive test? It's the date that their specimen was collected. So it's the day they got that cheek swab or had their nose pierced by a medical professional, and the sample was taken, okay? It's not the date that they got their test results. So if there was a delay of 4 or 5 days, we actually are going to use the date that they delivered their specimen to a medical facility for testing. Okay, so in your initial inquiries to any claimant, that should definitely be one of the questions you ask. When did you get tested? You want to know, but for purposes of establishing the date of injury, which the date of injury is huge because that tells us which provision of the statute we're really looking under. You need to know the date that their specimen was collected, and you need to know the last date that they actually worked. There are some kind of funky fact patterns we've seen where someone thinks they have COVID, but like not really. They just kind of go get tested because a family member was getting tested. And so why not? Let's all get in the van and go get tested. It'll be a fun day. They keep working irresponsibly if they think they have COVID. But again, in some cases, people didn't really think they had COVID. They just kind of got tested. Surprising some of them, their test results come back positive. Okay, so you would still use, by law, the last date they worked prior to the date they delivered the specimen, even if they continued working afterwards. Now, a more common fact pattern there is going to be that the employee gets tested, is positive, quarantines, recovers without any prolonged disability or illness, and then goes back to work. So maybe at the time they file the claim form, they have actually returned to work. We still go back by law now to the last date that they worked prior to the positive COVID test. That is their date of injury. As clear as that sounds, there is no discussion in the statute about whether this is a specific injury date or a cumulative trauma. So on the defense side, we still retain all of our rights to seek a finding that it's a cumulative trauma to the extent that helps us bring in other potentially liable parties. So if your employee happened to be working at another job, or if there are multiple carriers on risk pursuant to Labor Code 5500.5, then we want to make sure that we try to get the doctors in the case to indicate that the date of injury is this date, but perhaps that date is the last date of a cumulative trauma exposure, okay? The second big change that actually is also good for defense is that the medical provider network can be enforced for purposes of administering medical treatment and for temporary disability certifications. So if your employee refuses to go into the medical provider network and they have not properly pre-designated a non-MPN physician, then you have certain rights and remedies that should absolutely be discussed with your claims examiner or your attorney. That's kind of what we do. All right, so that's Section 2 in a nutshell. Section 3 addresses, again, a narrow subset of employees. We're looking at safety officers, first responders, and certain specified healthcare workers. Okay, so not all healthcare workers and not everybody who bears a badge is going to qualify under this. But if they fit within the narrow determinations of the statute, they will get the benefit of Section 3. Section 3 also creates a rebuttable presumption, meaning we have the ability to challenge it in certain cases, for first responders and healthcare workers. Now, for healthcare workers, there's a requirement that they be in direct contact with COVID-19 patients. And if it's a custodial employee at a health facility, it only requires that they be in contact with the COVID-19 patients. So cleaning out a room after a patient has been discharged might qualify as contact. There's no requirement that the custodial employee be in direct contact. That's an important distinction for those of you who have janitorial, health services, environmental services type employees. All right, so again, date of injury is defined the same way as our discussion under Section 2. It's the last day actually worked prior to the positive COVID test. The PCR test is required. And Section 3, just like Section 4 we'll talk about next, applies to dates of injury on or after July 6th. Okay, so for the Section 2 presumption, and as with the executive order, there was no limitation based on the nature of the work that they were doing. So for dates of injury before July 5th, it really applied to any employee who was working at the direction of their employer other than at their own home or residence. Section 3 only applies to the specific types of employees who are enumerated in the statute, okay? There are many references in Section 3 to specific sections of the penal code. 830.1 is the big one, and that's going to define the general safety officers that this statute will apply to. If they're not covered by Section 3, they may be covered by Section 4. So if you happen to have security guards, anybody who might carry a badge, so to speak, but doesn't qualify here, they may still have a claim elsewhere. So again, if you think someone is going to qualify as a healthcare worker or safety officer under this section, that's a really good time to engage your counsel, engage your claims examining professional to help you identify whether your folks actually qualify for this. Either way, you still have to report under Section 4. Okay, and I want to make that abundantly clear. So even though Section 3 does not have a specific reporting requirement, if you have an employee that is within the parameters discussed in Section 3's presumption, you still have an obligation to report them. Okay, that's very important. All right, so back to Section 3 itself. The employee has to have been working at their place of employment at the employer's direction, again, not their home or residence. And there is what they call a post-termination provision in Section 3. If you're familiar with workers' compensation, a traditional post-termination defense is something that we on the defense side would raise to bar benefits to the claim entirely. That's not what this is. Under Section 3, and you'll also see with Section 4, all this does is it allows the employee to pursue benefits and file a claim up to 14 days after their last date of work, okay? And again, this is not 14 days after end of the employment relationship. So if you have somebody who stops working, but maybe they've got leave or other benefits, or for some reason they go out on a leave of absence that's authorized even without specific leave provisions, the employment relationship might not end for a month or two, but we still are looking for 14 days after the last day they actually worked, because that's their last date of exposure to COVID at the work site. So it seems fairly common sense to me that that would be added. Right. So we talk about covered employees. Here's a general list. I've already talked extensively about the safety officer provisions. There's too many to put on a slide. I'm not going to make you guys read a slide with all of the various codes. We can look that up if you have a question. But let's talk about the healthcare workers. Okay. So if you run a health facility, we're going to be looking at employees who provide direct patient care, custodial employees in contact with COVID-19 patients who work at a health facility, RNs, registered nurses, EMTs, paramedics. We're going to be looking for any employee who works for a home health agency that fits certain criteria that is providing direct patient care. We're going to be looking for providers of in-home support services, generally speaking, if they provide care outside of their own home, but there is a provision for those who provide in-home supportive services in their own home, as long as they're doing it in the capacity of an employee. So if it's just like me taking care of my mom at our shared home, that doesn't qualify. I'm a great daughter, but I'm not getting paid to do that, okay? So for purposes of this presumption, this really, the statute there was really more designed to capture like the state of California IHSS employees and those who are compensated for taking care of a family member or another individual, even if it is in their own home. Right. And then generally, this was a confusing part of the statute, employees of health facilities. And I read that and I was kind of like, well, didn't we already cover all, the specific employees of health facilities? If you're going to have a general employees of health facilities, why even bother with all these other classifications and making us learn all these other rules? Why not just say, if you work at a health facility, you're covered? There's a reason I didn't go into politics. I guess it's just too common sense. But here, the caveat to that is they have to be providing direct patient care or be the custodians that we talked about above. All right, so that's that catch-all. That last provision we talked about is really broad. For that reason, there was a negotiation effort implementing the bill to create a specific defense. Okay, and the defense is this: if the employer can demonstrate and establish, meaning we have to show facts and evidence, that the employee did not have contact with a health facility patient within the last 14 days that tested positive for COVID-19, then you can defend against for a health facility patient. Okay. So generally speaking, if you operate or if you do risk management for a health facility, you should be keeping records about all known positive cases. And I would suggest that you keep those records with the intent of showing which may have been exposed versus those who could not potentially have been exposed at all. So let's just say that your health facility also contains a medical billing office that's in the back. The employees that work there don't come through the general lobby of the health facility itself. Maybe they have a separate entrance, or maybe we're talking about a security guard who just patrols the perimeter of the health facility. They might be employees of that health facility, but it shouldn't be too difficult to bring a witness or two in to say that this person's regular job duties and during the period of time in which, you know, this case during which this case arose, they had no contact with COVID patients. So you should be thinking about your records keeping to the extent you can demonstrate that if these types of cases come up, if you want to exclude an employee that works at a health facility. Now, if that person has direct patient care, you can't defend on that issue, okay? You might still be able to show that they had non-occupational exposure, but that Section 3 presumption will initially apply, and you've got to then come back and rebut it. Okay. All right, now Section 4, the fun stuff. Section 4 basically applies to all other employees. So if they're not covered by Section 3, and there's a date of injury on or after July 6th, and the employee did not work exclusively at their home or residence, then they may be covered by Section 4. Okay. Section 4 created Labor Code 3212.88. It's also a rebuttable presumption, so we have all to defend it as evidence so. And essentially requires that the employee contracted COVID during a period of outbreak at their place of employment. Okay, so you could see why it wouldn't cover those who were exclusively working at their home or residence. It doesn't matter if there's an outbreak at the office. If they never go to the office, they were not exposed. Okay. Now, Section 2 and 3 that we just talked about have a 30-day decision period. Section 4 gives us another extension of that, and instead we have a 45-day decision period. I like to think that this was actually a bone that was tossed to the employment community because there is so much more communication required in order for a Section 4 outbreak analysis to happen. We'll talk a little bit about employer and the administrator responsibilities, and I think Tucker is going to talk more about the claims side of this when I'm done. But essentially, there's a lot of hand-holding and communication that really has to happen for this analysis to work. So if you do not know your employer contact or your claims professional contact, you need to develop that phone tree right now because there's a lot of communication that's going to have to happen. 45 days goes by in the blink of an eye, okay, especially when you also are trying to run an actual business. So it's a rebuttable presumption, 45-day investigation period. Section 4 also carries over the same rules about temporary disability. So if there's an employee who's unable to work because of COVID, and they're able to certify within every 15 days of the first 45 days of diagnosis, then they're entitled to temporary disability. Now, what I haven't mentioned yet, but is true for all of these presumptions, is that if the employee is eligible for supplemental sick leave under CARES Act, under AB 1867 that extended the CARES Act to certain employees, if they have any other supplemental sick leave benefits that are available specifically due to COVID, this does not attach to their regular sick leave or vacation, okay, that they had before COVID. But supplemental sick leave available to them due to COVID has to be exhausted first. And once that is exhausted, then temporary disability might be owed if they're properly certifying by a physician. Now, this part hangs people up quite a bit, and I tend to get a lot of questions about that. I do recommend if you have a question about whether your employee with COVID is entitled to additional leave, that you contact an employment law attorney who specializes in wage and hour analysis, because the supplemental sick leave policies are very specific. It depends on what their job classification is. It depends on how many hours they've worked in a certain period of time. And I am just a lowly workers' compensation attorney. So all things work comp, I got you. But this is an area when we're dealing with coordination of benefits where you really want to have your general counsel, your employment law counsel, and your work comp attorney and your claims examiner all communicating. And who doesn't love anything more than getting as many attorneys and insurance representatives around the table as possible, right? So, okay, all jokes aside, it's a serious issue. We don't want to overlap or duplicate benefits because it's very unlikely that you're going to get a credit. Not that you're not entitled to it, but it's going to cost you more in most cases to petition for credit at the Workers' Compensation Appeals Board than it is to just simply pay out the 2 weeks of temporary disability. So that if that's a concern to you, if you have a number of employees going out and you're unsure of the leave allowances or temporary disability, this is a really good place to bring in your claims examiner and your attorneys and really discuss what your options are. All right, so again, as we discussed with Section 3, Section 4 has a 14-day period following their last date of work for the employee to file a claim. Really important here, if you're a small employer, there's a little bit of relief. And by small, I mean you have less than 5, so employees. The Section 4 reporting requirements, the Section 4 presumption does not apply to you, okay? So don't hang up, there's still some very valuable stuff coming. But if you happen to be a small employer, just understand that you get to wave that little flag in front of all your big employer friends and say, haha, I don't have to report, have fun with that. And that becomes very important. Now, most of you are going to be bigger employers and have more than 5 employees. If you have 5 or more, all of these reporting requirements do attach, and you are going to be responsible for the results. Okay. Again, date of injury is consistent under Section 4 as the last date that the employee actually worked prior to a positive COVID test. So let's dig in a little bit to Section 4 and triggering the presumption. Okay. It's going to apply to any employee other than those covered by Section 3, and it's triggered for dates of injury on or after 7/6. Positive test, PCR test, or FDA-approved equivalent is required within 14 days of the employee's last date of work, and that positive test has to have occurred during an outbreak. So, claims administrator has the responsibility to determine an outbreak. It's an ongoing duty, as we'll discuss in just a minute. So again, it's very important that the employer and the claims team have good relationships and good communication here, because without the employer reporting, the claims member cannot do their job. Okay, so we really have to support each other so that none of us get penalized in the end. We're going to talk about outbreaks now. I want to make it clear that if there's an outbreak at one location, that does not mean that all of the employer's facilities or locations are going through an outbreak. This analysis, as well as, we're going to talk about reporting the number of employees reporting to work. All of this analysis right now for an outbreak is location specific. Okay, so we're going to isolate each location where the employee worked, and we're going to run the analysis based on that location. Now, again, if you have an outbreak at one location, it does not mean that every employer-owned facility is having an outbreak, okay? There's 3 ways to have an outbreak. The first is going to matter, we're going to look at the size of the employer. So, and specifically, to be clear, we're not looking at the size of the employer nationally or globally or even throughout the state of California. What we're looking at is the number of employees who actually worked at a specific place of employment, okay, during a certain period of time that we'll talk about next. Right now, what we're really looking at is the number of employees who test positive within 14 days, forward or backward, of the claimant, meaning the employee who says they have COVID on an industrial basis, of the claimant's own positive case. Okay, but to get there and to establish if there's an outbreak, we need to get some other information. So the first thing that we have to look at is, as an employer, you're going to be required to do a tally of all the employees who actually worked at or reported to a specific place of employment in a 45-day period. Okay. So you measure employment attendance every day for 45-day period before the claimant's date, and you report one number to claims. That's the highest day attendance. So if every day you have 2 employees show up to work, but on one day you had 150 employees show up to work in that 45-day period, your highest number is 150, okay? Now, if every day you had 2 employees show up to that specific place of employment, your number is 2, okay? But we're not averaging, we're taking that one day on which we had the highest attendance at that actual place of employment. If you have employees who technically report to a place of employment but didn't actually show up to work there, that's not what we're counting here. It's only those people who actually physically go into the work site. Okay, so at a specific place of employment. Yes.
Just a quick question to clarify here. Can you talk about multiple shifts? Is there a requirement to address it by shift, by 24 hours? What's the requirement there?
It's a really good question. So we are measuring physical space. We're not measuring time of day. So I would recommend that you look at what is your reasonable business operating hours. If you are absolutely closed and you have no one go in, not even cleaning or janitorial staff at night, you could measure from 8 to 5 or however long your business is open. A safer bet would probably be to look at a 24-hour period, maybe 12:01 to 12 o'clock the next morning. Most companies are going to have people kind of coming in and off hours at some point. So it is on any given day, which is how the statute is worded. So it's not by shift. You just need the total number of employees who were in attendance at that specific work site on any given day within 45 days of the claimant's case. Okay. So if that number is 100 or less, we're looking at section 1 here. Okay, if that number is 100 or less, then we need 4 positive tests in order for there to be an outbreak. So 4 out of 100 or less. Now you might think, well, I only had 2 employees report to work that day. Well, you can't mathematically have 4 employees test positive, right? Within that 14-day period. So if you only have 2 employees reporting to work each day during that period of time, the question is, in that 45-day period, did you have a higher number? Because that's what we use. If it's still just 2 was your highest number, you can't possibly have an outbreak. But you still have to report all positive cases. Okay. Now, if the employer had more than 100 employees show up to that specific place of employment, then we're looking for 4%. If you're a large employer, you know that you've got more than 100 employees showing up to a specific work site every day, then you really want to try to get specific. I know this is a lot of tedious work to track your employee attendance, but the higher your number goes that you're reporting, fairly and honestly, mind you, but the higher your number goes, the higher the threshold is going to be for there to be an outbreak. So this is not a place to get lazy and to say, well, we know it was more than 100, so we'll just report 101. If you know it was more than 100, try to get as close to accurate as possible, because there's a big difference between having to show, 6 positive cases for 150 employees or having to show potentially 40 for, 1,000 employees. So try to get it right. All right, now the third ability to show an outbreak, or the third requirement, we should say, is whether or not the specific place of employment has been ordered to close down due to concerns of COVID by a state or local public health department, by OSHA, or by a school superintendent if it's a school site. Okay, so everything that we've just mentioned with determining an outbreak deals with specific place of employment. So let's talk about what that means. At the top of the slide here is the definition from the code. Okay, it says a specific place of employment means the building, store, facility, or agricultural field where an employee performs work at the employer's direction. Does that mean that if you can make an argument that none of those apply to your employee, that you don't have to report or that you're not going to be subject to an outbreak? I would like to say that, and if you have the right facts, we can argue that until case law tells us otherwise. And I would absolutely hold on to valid defenses to the extent you can. But I would also say that you need to be realistic and understand that this is probably not going to be exclusively defined in this way, and that what the senators who drafted this bill have mentioned multiple times after its enactment and in the journaling process where they add additional comments is that their intent is for this bill to be broadly construed in correlation to Labor Code 3202, which liberally construes any ambiguities or gaps in the Labor Code to the employee's favor. Okay, that doesn't mean the employee is always going to win. And again, you need to pursue reasonable defenses where you have them, but you also need to understand that it's an uphill battle and you need good evidence to be able to overturn any kind of ambiguity. So for now, we have this technical definition of specific place of employment. We know that by code, it does not apply to the employee's home or residence unless they're that small niche of people providing in-home support services at their own home. And if the employee works at multiple locations, so let's just say they are a delivery driver who does internal deliveries to all of your own facilities, okay? If that employee tests positive, their positive case has to be reported and it attaches to each physical location where that person did their regular job, okay? Now, I get a lot of questions about field workers or folks who might start at one location and then go out to customer locations off-site. Potentially, yes, each of the places that they visit could be considered a specific place of employment. If you want to be completely technical, I would measure each of those locations. But I would also throw out there the realistic idea that attending and doing job services at a customer location, as an employer, you're only required to report your own employees. You are not going to be responsible for reporting all the employees who worked at each customer location that person provided field-related services to, okay? So can you have an outbreak if you only have one employee at a location? No. But do you still have to report it? Quite possibly, yes. The duty to assess whether there's been an outbreak is ongoing. And so we'll give this little example here. I think this really helps illuminate this idea. If on day one we have a small business, just 100 employees and one business location, okay? Day one, they have 3 COVID infections that are reported. None of them are covered by the outbreak provisions at this point because we need 4 cases, okay? Now, each of those 3 positive cases might still have an industrial injury. Just because they don't qualify under the presumption, it does not eliminate their right to pursue workers' comp benefits separately, but they don't get the benefits of the presumption. So they file it under a regular work comp case for COVID. They get a 90-day decision period and all the usual rules of comp apply, okay? Meaning they have to provide evidence of injury. With the presumption, it's assumed that they were injured on an industrial basis, and then we as the defense community have to fight against that. But so let's come back to outbreak. So if the employee has 100 employees and one business location, the day one, they have 3 positive cases. None of them are covered at that point. Now on day 10, so we're still within a 14-day period, on day 10, the employer learns of a new positive case. Well, now, I mean, I can even do this math, right? So 3 + 1 becomes 4, and now they've met their requisite 4 positive cases within a 14-day period. And now all 4 cases are presumptive. Okay, so that's what we mean by ongoing duty to assess. And this is where claims administrators are starting to drink or eat heavily because it's really, you can never really rest. Any new positive case reported has to then be retroactively analyzed, and all other cases that came up within a 14-day calendar period of the new case also have to be retroactively analyzed. Okay, so you could properly deny all 3 of those cases that came up on day one as not fitting within the presumption. But then that 4th case comes in and claims has an ongoing responsibility, and we'll probably see a lot of audits on this basis to go back and reanalyze whether or not those other cases should. Okay, here I want to make clear, we look at positive cases within a 14-day period before and after the current claimant employee's date of injury. Okay. Now notice that I'm saying positive cases and not workers' comp claims. You as an employer have an ongoing duty to report positive cases. Okay. We'll get to that in just a minute. But again, if a presumption doesn't apply, the employee may still be able to pursue regular workers' compensation benefits. It's not a total bar. It just makes it harder for them to do it. Okay, so now let's talk about employer reporting and why a second ago I said positive cases, not positive claims. A positive case exists when the employer knows that an employee has tested positive. And even if that employee comes to you and says, I tested positive, but my Aunt Judy got me sick when we went shopping, you still have an employee who showed up to work and now has tested positive. That is a case that has to be reported to claims. Okay. There are significant penalties if employers do not report properly. Up to $10,000 assigned by the labor commissioner. They'll probably start smaller, but if there are egregious violations, similar to what we're seeing with, I suspect that they will start implementing the highest possible penalties, just to make an example. Okay. So employers have 2 distinct periods of reporting. The first one we're going to talk about is the ongoing duty to report. For any cases that arose after 9/17, which again is the date that the governor signed the bill, any positive known cases of an employee who reported to work after 9/17 need to be reported to the claims administrator. Okay, for SB 1159, the employer reports to the claims administrator within 3 business days of learning of the positive test. Okay, Employers ask me all the time, do I have to go back and poll all of my employees to see if they positively tested? No. In fact, you probably should. But if an employee tells you they tested positive, or if you learn about it from another verified source, now you have a reporting requirement, and that reporting is to your claims administrator with the following information. Number one, an employee has tested positive. The reason this says an employee instead of the employee is that if that person has not filed a workers' comp case, you cannot report personally identifiable information. If the employee has filed a workers' comp case or comes back later and files a work comp case, then absolutely you have to report their personal information so that claims can set up their case. Okay. But if all you know is that someone tested positive, you know who they are, you should be keeping as an employer internal spreadsheets. But for claims purposes, you cannot report their personally identifiable information, just that they had a positive test. Okay. The second thing you have to report as an employer is the date that the employee tested positive. That again is the date the specimen was collected. The third thing is the specific address of the employee's specific place of employment for the 14 days prior to their positive test. Okay. For this purpose, we're only looking at the 14 days prior to their positive test. So if they tested positive on September 1st and got their results on September 10th, we go back 14 days from September 1st, and we look at all places where that employee actually performed their work. Okay. That is the address and location that you report to your claims department. If you have multiple facilities, I highly recommend that you identify each facility with a distinctive name or number so that you can have consistent reporting and help your claims professional out when they're analyzing outbreak. The last thing you have to report, again, within 3 business days of learning of a positive case to your claims administrator, is the highest number of employees that reported to work at that employee's specific place of employment for 45 days prior to that employee's last date worked. Okay. Fortunate enough to have employees who migrate between offices. If they have multiple locations, then you have to report that number for each location where they worked. I kind of joke that this should have been dubbed a job creation bill because of all the data tracking that's going to be necessary under it. For some reason, people don't find that funny, but lawyer humor. All right, civil penalties. So it was very interesting that the penalties here go to the labor commissioner. The statute specifically authorizes not the Workers' Compensation Appeals Board, but the labor commissioner to enforce against employers. There's some jurisdictional questions there about who really has authority over an employer. And I think that's resolved by having the labor commissioner do this. Now, if you don't properly report, you should be wary of this, okay? If you intentionally, as an employer, if you intentionally misreport, you should be very wary of this. I believe that accidental failures to report proper information, maybe because you didn't understand it or you had some numbers come up later that you didn't supplement your reporting with, is going to be treated at a less significant level than employers who are deemed to purposefully or conscientiously ignore these rules. Okay. Again, the labor commissioner can penalize up to $10,000 for each violation. And there's a lengthy appeals process. There's a lengthy process described in the statute, but let's deal with that. Hopefully none of you get there because you have attended this presentation and now you know exactly what you're supposed to do. If you do get cited by the labor commissioner, just know that you have 15 days to pay or sway, as we say, to appeal. Okay. All right, so we've talked about the first reporting requirement from employers. That is your ongoing duty to report within 3 business days when you learn of a positive case. The second employer reporting requirement covers that gap period that we talked about earlier. So that's going to be the period from when the executive order ended, so July 6th, until SB 1159 was signed and effective. The second employer reporting period is from July 6th to September 17th. This period, you have to report the test, the date of the positive test for each employee that tested positive, and also the address of employment for each positive employee for the 14 days preceding the positive test. So you can see it's very similar to the ongoing 3 business day requirement. 2 major differences. Instead of going back 45 days to look at the highest number of employees, all you have to do is look at the highest number of employees that reported on any given day from the period of July 6th to September 17th at that specific place of employment. Okay. Now, The other thing about this that's different is you now have 30 business days from September 17th, which I calculate it's about October 29th, okay? But from September 17th, you have 30 business days as an employer to report this information to your administrator, okay? So that's it, you guys. There's 2 major employer reporting requirements, and there's a lot of legwork done for you to get the data to your claims administrator. But I hope that that demystifies and sort of closes the universe of your responsibilities. Now, this does not eliminate all of your regular responsibilities to provide wage statements and information and assist your claims team. Your policies include an obligation to work in good faith with your carrier and TPA. So none of that changes, okay? We're going to just have a couple more slides real quick, and then I'm going to turn it over to Ms. Tucker. So 1159, a quick summary. I find after I jam all this information in your brain, it's kind of helpful to just put it nice and calmly into one area. So SB 1159 establishes 3 distinct presumptions. They each have their own rules and requirements, as we've talked about. The first is a codification of the executive order, which covers the dates of injury 3/19 to July 5th, 2020. The second applies to safety officers and healthcare workers. And the third is the outbreak provision requirement for all other employees. The second 2 apply only to dates of injury after July 6th. Okay. The general analysis that I recommend anyone do, whether you're an employer, a claims professional, an attorney, et cetera, is number 1, identify the date of injury. Number 2, identify the type of work and job duties done by that person, as well as the location. Then determine which presumptions are going to apply and see if they've met the requirements of each or any presumption. Conduct a thorough analysis and investigation. If appropriate, hire an AOE COE investigator. That's a decision that can be made in conjunction with your claims team and attorney if that's necessary under a particular case, to see if you can then rebut the presumption. All 3 sections are rebuttable, so don't give up any of your rights. If a presumption applies, you might still have defenses. And then consider if you've already denied a case, if there are new facts or information or body parts, consider how and when you're going to issue additional denials based on the presumption applying or not applying. In many ways, these are really significant changes for employers and the claims administrators. So we're all in this new normal trying to figure out what we need to do. Communication is key. One of the major communication points that's going to come up is as it relates to specific places of employment. So there's a few kind of 30,000-foot view issues that construction contractors who have gig economy have classified as employees, but you've always thought of them as independent contractors. Large complex locations where we've got multiple business operations on a site, but really there are distinct buildings or facilities. Airports come to mind. You might have maintenance hangars and you might have delivery or shipment hangars that never touch the public terminals, right? So I think a cogent argument could be made that each of those locations that operate essentially independently, even if it's for the same employer, could be deemed different locations, different places of employment. With regard to the first 2, the construction contractors and the gig economy, what we're really looking for here is who would be covered under your insurance policy. If it's your employee, if you have liability for them as an employer, they should be reported, okay? So better safe to report than sorry and under-report or not properly report. If you have specific questions, we can talk about your location. The last button here is for vendors who are working on site. Now, your obligation under SB 1159, okay, and I'm clear, SB 1159, is to report your own employees. You do not have to report every single person who comes onto your job site. Particularly troubling would be a situation where we have a commercial location where customers are coming in. Let's say that you find out a customer tested positive. They're not your employee. You don't have to report that case to your claims team under SB 1159. Okay, now, would it be a good idea to probably review your vendor and subcontractor arrangements right now to make clear who has liability? Absolutely. And if you have any questions about whether your insurance policy covers specific people working on your job site by contract or otherwise, this is a good time to start asking those questions. But I will tell you that nowadays, most insurance policies, maybe not all, most insurance policies have an exception for what we call special employees. Okay. Now, if you're a temp agency, your spidey senses just tickled, and they should. Let's follow up afterwards because there's a lot of different things that may apply to you if you use temp agencies as well. All right, so we want to have a clear reporting structure, and this is going to come into what Michelle's going to talk about in just a few minutes here. But the last thing I really want to emphasize here is that your knowledge of an injury is different than your knowledge of a positive case. As an employer in the state of California, if you have knowledge of an industrial injury that results in disability, meaning time off work, or medical treatment beyond first aid, then you have an obligation to provide a DWC-1 claim form. Okay, I get a lot of questions about the claim form in light of these presumptions. I also believe, and I take a conservative approach, I also believe you owe a claim form if you know that an employee qualifies for a presumption. So if you know that they had a positive test, if you know that there was an outbreak during the time that they had a positive test, if you know that they qualify under Section 4, I think you owe them a claim form. You're not going to get out of liability if you know that they test. Figure it out. And what happens when you don't provide a claim form when you're supposed to is their ability to file that claim gets told. And we've all seen cases where people come back years later and have the right to pursue benefits because they did not get a claim form when they were owed one. So I'm also not saying, and let me be clear about this, that you have to give every employee a claim form if one employee tests positive. Okay, it's on a case-by-case basis. But if you know that this person clearly qualifies for the presumption and they have an injury that results in disability and time off work on an industrial basis, they're probably owed a claim form. The simple standard for do they need to be reported to the claims administrator is whether they've had a positive test. Any employee with a positive test should be reported under Section 4, as long as you have at least 5 employees. Your attorney should be working with you to develop the record to defend these cases, and developing the record might also include developing non-occupational sources of exposure and apportionment. Apportionment means that if somebody came in injured, let's say they have pre-existing asthma, COPD, heart issues, and then they have pulmonary or cardiac failure or other issues in response to COVID, unless it's a death case, you don't get apportionment in a death case. But if they have permanent disability, we could still argue that your exposure should be lower because of their significant pre-existing conditions or prior awards. Okay, SB 1159, done. We're going to move on to AB 685, and I want to make it very clear now, this is a separate bill, different reporting requirements. It's going to be a very brief discussion, although it's a longer bill than the next 2 slides would give you credit for. We're going to be doing specific follow-up on 685 in other webinars. It does not become effective until 1/1/21. Okay, so start preparing now. Put those nuts away for winter, but it does not become effective until 1/1/21. Okay, AB 685 requires employers who knew or should have known of an employee COVID exposure. Okay, not positive test, but exposure. They have to report that to the Department of Public Health within 24 hours of learning of that positive potential exposure. Okay, violation of AB 685 is a misdemeanor, and it also requires the employer who is aware of a potential exposure to notify other employees and representatives at the work site where exposure occurs. There's probably some HIPAA tension there. You can't report, hey, Jane Doe contracted COVID and you guys worked with her. That information probably gets out just naturally, but your reporting and notification requirements are that, hey, you worked at this job site on this day. We've become aware that you may have been exposed to COVID. What that does is it triggers their knowledge so they can go get tested. Okay, it's pretty simple. The enforcement provisions do have teeth, though. AB 2537 was also enacted requiring provision of PPE to hospital workers that provide direct patient care. There's also a bill that came into place requiring education of farm workers and agricultural employees on the hazards of COVID. The underlying premise there is that those folks are not sophisticated and may not be otherwise informed. Okay, so again, 685 effective 1/1/21. It was passed on 9/17 alongside SB 1159, but requires reporting to a different source. Okay, AB 685 is going to apply to public and private employers. who receive notice of potential exposure to COVID. Generally speaking, I'm recommending we follow CDC guidelines on developing what is a potential exposure. I think that's the safe course for now, since it's not clearly defined in the statute. And then you have to notify all employees as well as the employer of any subcontractor who was working on site at the time of the potential exposure. OSHA has the ability under the statute to declare that there was a serious violation. You don't want to run afoul of OSHA. One serious violation, but if you get another or another after that, it just sort of grows exponentially. When there's a realistic possibility that death or physical harm could result from the actual hazard created by violation of this. So they're notified, potentially exposed. One of them gets COVID, gets hospitalized, or dies. You are now, as the employer, responsible for that to OSHA, and there are serious and significant penalties. COVID is still little understood. Okay, so OSHA, Labor Commissioner, they're being very conservative on these penalties. And this was on this slide just last week on September 30th, there were very hefty fines. Now, these are proposed penalties because with OSHA, nothing is final. You can challenge a penalty. But the proposed penalties went all the way up to $25,000 per violation for what OSHA deemed as a failure to properly protect employees. For example, by simply installing plexiglass barriers or separators. Failing to provide effective training for employees, including instruction on how the virus is spread, how to avoid infection, how to identify the infection, and provision and training on use of safety cleaners. So these seem like very straightforward ideas. And in fact, OSHA put out a memorandum on July 16th with these specific preventative measures that employers should be taking. Now they're enforcing against employers who have not taken these very basic procedures. Now, I like this slide as well because it always reminds me to tell you that under Section 4's outbreak provision, there is a specific defense. If you are an employer who's been determined to have employees exposed during an outbreak, but you can show that you've taken significant safety precautions to prevent the spread of COVID, as you see on this slide, you can defend against that presumption. So even though you had an outbreak, you can show that it was more coincidental and not because you were failing to take precautions. I don't do OSHA myself, but the 3 attorneys at my firm who do are on this slide. If you have OSHA specific questions, you can follow up with them anytime. Pat McAleer has been doing OSHA longer than I've been alive, as he will proudly tell you. Okay, so now we get into Corvell's presentation. Madam Michelle Tucker, I'm going to turn this over to you now. I'm sure everybody is sick and tired of hearing my.
We'll let you grab a drink of water too, because I'm sure you're a little.
Thank you.
I don't know what
coffee is my drug of choice.
Okay, this is actually the second or third time I've participated in a presentation, and every time I participate, I learn something new and come up with some additional questions to ask. So I'm going to go quickly through this because I know we have a number of questions from the audience. I just want to speak briefly to the Corvell response related to SB 1159 for our customers on the call, where your resources are at Corvell and what we're doing to support you in dealing with or addressing SB 1159. So with that, if you can move to the next slide. Just quickly wanted to talk about Corvell's COVID-19 numbers so you have a general idea of what we have. We have had about 15,500 total COVID-19 reports. About 7,700 involved medical care. So a great many of these ended up just being exposure cases, frankly. For the most recent week ending 10/3, we have seen an increased volume in 16 states. That was primarily in the Midwest. We did see a decreased volume in 14 states, sort of the interior United States, excluding the Midwest. And we have seen an overall incoming claim volume that was down last week, about 24%. I will say with an asterisk there, this week we seem to be picking up again. So I don't know if it was a matter of just claims not being reported last week, but this week frequency certainly has picked up again. Thankfully, 70% of all the claims that have been reported to us are closed. Excuse me. So we're happy to see that happening. Our average COVID-19 claims cost is about $3,000, and that is for claims that do have medical treatment and or lost time. And thankfully, I think what is most important for all of us is less than 1% of the claims that we've received, again, this is based on our experience, haven't incurred greater than 75% or were death claims. So very small percentage of severity, thankfully, thus far. And we're appreciative of that, and certainly we're appreciative that our employees are recovering well. So, all right, next slide. So we are providing updated legislative information on a regular basis on corvel.com. So we post whatever we receive nationally there. There's a list of states that have presumptions. Thankfully, things have slowed down a bit with the exception of California. New Jersey had a recent change that we've included as well, but most of the states have been somewhat stable in legislation related to COVID, but certainly there's a resource there. And again, we keep that updated on a regular basis. For our customers, your account managers have been designated to provide employer training on your reporting options relative to the Senate bill. We've had a couple of internal sessions. I know a number of them are participating on this call as well. They should be reaching out to you to walk you through the process and, again, to provide the resources that are available, in particular for capturing these employee-positive tests, non-work related, but also non-identifiable information. I'm actually going to show you a screenshot in just a second of the reporting site that we've initiated. We also have a paper document if you prefer that, or you can partner again with your account manager to provide those non-identifiable employee-positive tests. We will be, as Brenna mentioned, our claims team performing an ongoing assessment of an outbreak. And again, but that is based on what is reported to us. So what is most important is that you get that information to us, whether it's alleged to be work-related or not work-related. Anytime you have a positive test, we need that information submitted to us. And our job is going to be immediately to reach out to you when we've identified a potential outbreak at a particular work site so that we can work jointly to make sure all of those claims are evaluated to determine if they qualify under the presumption or not, or if we have a defense. And that obviously will involve an investigation and collection of very important information from you. All right, next screen or next slide. This is I know it's a little small print on here. This is actually a screenshot of our reporting site. Information that we would like to collect from you if possible. Positive testing information, again, the date the actual test occurred or was collected. We have the ability to include multiple locations. So again, if you have an employee who works at multiple sites, you can submit that here. As an employer, when you save this particular report will be assigned a reporting number so that you can cross-reference it to your internal listing or spreadsheets where you're tracking who's been reported. So you'll actually have a reference number assigned to it as well. And this is active currently. Again, your account manager can walk you through where this is located in the Corvel system, in the KRMC system, and make sure you have access. All right, next slide. So wanted to mention a couple other things post Brenna's conversation, in particular as we move towards the AB 865 that's coming up. Is it 685? 685. Sorry, dyslexia. And what we can do to help you in some of those pieces. Corvel does offer employee assessment screenings for help in returning to work. So our nurse case managers can work with your employees to do temperature screening. They can provide a questionnaire, a simple one-page questionnaire to, again, try to do due diligence in making sure employees are healthy and well and returning to work. They can also provide COVID-19 training based on CDC guidelines, can also provide supplies such as some basic masks or thermometers to employees. So we have that available as well. And I think certainly that would document well your attempt to provide education and resources and an understanding of COVID to your employees. We also have critical event debriefing in the event that you have an unfortunate situation involving maybe a significant illness or death of an employee, whether that's related to COVID or not. I would like to point out we can provide supportive services to your employees if an unfortunate situation like that should occur. And then, of course, virtual treatment. With COVID, we've really seen this blossom. Corvell, we were providing virtual care prior to COVID, and thankfully it was up and running long before COVID hit. So not only can we provide virtual physician services, we've expanded that now for virtual physical therapy, virtual mental health therapy, and we've also recently kicked off a virtual service, which is prehab for employees who are preparing for surgery. We partner with an app to provide them with some physical conditioning programs to, again, physically prepare them for surgery. So we have lots of solutions available to you and resources. We want to make them as available as we can to you to opportunize your preparation and certainly documentation ahead of some of these changes coming with the upcoming Assembly bill. All right, with that, next slide. I think we are good on this piece. Again, we wanted to try and provide plenty of time for questions. So with that, I'm going to open it up to Diane Blaha to cover the questions.
I would just say,
well, thank you, Michelle, and thank you.
Oh, sorry, Diane, before we get started, I ask a question